And in this scenario that I'm curious about, we have our client who has a joint held, let's just call it a credit card, that they are on the account and their former spouses. They seek relief, they get their discharge, but in their divorce decree, it provides that each spouse is awarded to pay half of their marital debt. What happens when they file bankruptcy and then their former spouse is now being collected on by this other, creditor? What can happen to the individual who filed bankruptcy, and what is likely to come?
People will think after they get their divorce decree that they can go through this bankruptcy process and that they can avoid having to pay their spouse, having that debt discharged to the creditor, right? But you're not necessarily avoiding having to pay your spouse. That debt isn't going away. So what happens here a lot of the time is we'll look to the actual contract, the actual divorce decree. We'll look to the terms in there. Here you mentioned that both parties were ordered to pay half of the debt to the creditor directly. And so in that situation, we'll typically look beyond that clause. We'll look for some sort of an indemnity clause or something to those lines. Even though that debt may have been discharged to the creditors, the party still owes that money to the other side, right? Now we're talking about an unequitable distribution of the debts because, one side is being ordered to pay half, the other side half, but that's getting discharged. So now we've got that, it's no longer an equal division. And so the indemnity clause in this situation would likely come in. The party who's wanting to enforce on the other side would need to file a petition to enforce in the family court. And typically the family court would order them, at least in this hypothetical situation, to still pay that money back to the other spouse.